All right, good morning, and welcome to our fourth and final week of our County Officials Workshops, or COWS. My name is Sarah Diedrich Hasdorf. I'm the Deputy Director of Government Affairs at the Wisconsin Counties Association, and I'm going to serve as our moderator today and get things kicked off. Just a couple of housekeeping notes before we begin the session. You should have received today's PowerPoint presentations last week via email. If you did not receive them, they can be found on the WCA website, www.wicounties.org, then click on events, and then click on past event materials. On that same website, you can find recordings and materials from the past 3 Mondays. Recordings and materials can also be found on the Division of Extension Local Government Education website as well. Just a few quick housekeeping notes. If you notice any technical issues during the presentation, please send a note using the chat feature in Zoom. Chelsea Severin, our technical expert, will be monitoring that throughout the presentations. If you have any questions during the presentations, please utilize the Q&A feature in Zoom. We will be monitoring the Q&A feature, and depending on time, we may take questions during the presentation or after the individual presentations. If we see a question on there that we feel needs to be addressed immediately in order to provide clarity, one of us will jump in and ask the presenter to answer the question right away. We are willing to stay on past 10:30 as well to ensure that any remaining questions get answered that we are not able to answer during the time we have allotted for today's session. Today, we are going to be talking about Wisconsin's public records law and ethics and conflict of interest. We have 2 distinguished presenters from the University of Wisconsin-Madison Division of Extension with us today. I'm going to introduce both of them right away, as one may interject in the other's presentation. So speaking to you on public records today is Daniel Foth. He is an attorney. He is the interim program manager at the University of Wisconsin-Madison Division of Extension, Local Government Education. And then our second presenter today, who's going to talk to you about ethics and conflicts of interest, is attorney Philip Freeberg. He is a distinguished lecturer at the UW-Madison Division of Extension, Local Government Education. So if I didn't miss anything in the introduction, I'm going to turn it over to Daniel to talk to us about the public records law.
Good morning. Thank you, Sarah. Just one quick note. I'm actually retired as an attorney. I let Philip do all the real attorney work now. And speaking of Philip actually wrote the book on public records. If you have your Wisconsin Counties handbook, Philip has done the public records part of that handbook or chapter in that handbook, I think for the last 3 handbooks, maybe more. And I'm sure he'll be interjecting himself today if I say something incorrect or if one of you stumps me with a question. So with that, I'm going to share my screen here and we can get started. Oops. What the heck happened here? There we go. Okay, I also want to acknowledge the Office of Open Government, Wisconsin, at the Attorney General's office. They have a lot of terrific resources, and they are the arbiter of all things public records and open meetings, so it's a great place to get information. And finally, Claire Silverman at the League of Wisconsin Municipalities was also helpful in getting the original presentation put together on public records. So today's goals, we're going to talk about policy, terms and concepts, notice and hours policy, request response costs, enforcement, maintenance and retention, and resources that'll be available to you. So let's start right off with the policy. The Wisconsin Statutes 1931, the goal of an informed public, and that's the key word, informed public or words, requires giving the public the greatest possible information regarding the affairs of government. So the presumption under the public records law is that there is complete access consistent with the conduct of government business. Denial of access is rare. It is generally contrary to the public interest, and only allowed in exceptional cases. So keep that in mind. The presumption is complete access, and denial of access is rare. The authority. Any of the following: a state or local elected or local office, an elected official, agency, board, commission, council, or department, quasi-government corporation, subunits. All of these folks could have custody of a record. The custodian is the entity that maintains the records and makes decisions about access. Elected officials are custodians unless they designate an employee. If no one's designated as the highest ranking officer or chief administrative person. Some statutes designate clerks as keeper of records. And highly recommend an internal records procedure. As I go through this presentation this morning, there'll be a lot of reference to an internal records procedure. This basically tells your employees, your elected officials, and the public how you will enforce and operate under the public records law, and provides consistency of response and ensures compliance. That's the whole reason to have an internal records procedure. So public record.
I think also, Daniel, the statute requires it.
The statute requires notice. That's what I'm suggesting here goes a little bit further, but we'll talk about that in a minute. So definition of a public record. Public record is a record of an authority. A record is any material, written, drawn, printed, spoken, visual, electromagnetic, electronically generated, or stored data that is recorded or preserved, regardless of its physical form or characteristics, that has been created, keyword, or kept by an authority. And just as some additional information about records, contractor records produced and collected under contract with an authority are public records. The law covers access to records, not answers to questions. We'll talk about a little bit more about that shortly. And reminder, content and substance is what's important, not the location or the format. What's not a record? Drafts, notes, preliminary computations. So if you are an elected official and you take notes at your meetings, but they're for your own use and not to be shared with other folks, then those are draft notes and not public records. If you have working on a report that's not finished yet, the draft report would not be a public record. It becomes a public record once it's finished. However, just putting draft on a report does not mean that it exempts it from being a public record. Personal property does not relate to the custodian's office. So for example, your personal emails are not public record unless you mix public business with your personal email. And again, exceptions are narrowly construed. Business and email. Again, personal emails, documents on the authority's account. So if you have a personal email mixed with something that isn't personal, that the part that isn't, that's public information is disclosable. The personal email parts are not. Government business emails, calls, documents on private accounts. So if you receive an email on public business on your personal email account, they may be records, but again, it's the content of the item, not the medium or the location. And for those of you who are complying with public record requests, I suggest you conduct a careful search, especially if you know that the information may be residing on both government-owned computers, tablets, cell phones, as well as privately owned. Employee records. Generally, access is not permitted for employee records, their home address, email, phone number, social security. That just makes perfect sense. If there's a current investigation, their employment examination except the score, staff management planning, performance evaluations, etc. Other personal related items, including disciplinary records, may be subject to disclosure. And notice to employees may be required in certain circumstances. And so if you have a record, if you have someone request an employee's record, take a look at statute, Wisconsin Statute 19356, make sure that you stay in compliance. Electronic records, any social media accounts, Facebook, Instagram, Twitter, whatever you have. If you created it or maintain it, that's a public record. Cell phone content, we've talked about that already. Phone call records, text messages, any item sitting in the app. It's important to check cell phones when gathering records. And one thing I wanted to say here is another reason to have a public records policy is you can state in that policy whether employees or elected officials should be using their personal cell phones for public business. There was a county that I was told about a couple of years ago when I was giving one of these presentations where the employees were trying every type of messaging app each day to communicate each other about county business. So if you had a policy, you could basically say, no, you only use the official media for those conversations instead of just anything you feel like. Electronic databases. Direct access to electronic database is not required. You may put reasonable restrictions on the manner of access to the original record, especially if the record is irreplaceable or easily damaged. There is a Wisconsin statutes, the computer program itself. So if you have a lot of records in Word, the Word program is not subject to examination or copying. However, what went into the program, in other words, what you typed in, and the output, what is produced by the Word program, are public records. The requester, within reasonable limits, may request a data run to obtain requested information. And a good rule of thumb, again, content. The content determines whether it's a record, not the format that it's kept in. Metadata. Metadata is data that describes other data. There's three main types: descriptive, which describes the resource for purposes of discovery identification, like a title, author, keywords. It would be the header on your email saying you're the person who sent it. Structural metadata indicates how the compound objects are put together, how the pages are formed into chapters, etc. And administrative metadata helps manage the resource, such as the file name, technical information, who can access it. Last year, there was a court case, Luters versus Krug, where the Court of Appeals found that metadata that contained electronic version of an email but had additional information not found in the printed version was in fact a record and should be provided when requested. Notice and hours. So as I talked about earlier, it's good to have a public records policy. The statute requires at a minimum you post notice and hours, who is the custodian, the time and location to inspect records. If you have no regular hours, advance notice as to when to inspect and what the costs are to obtain records. If you do not have regular hours, then your notice should at least show 2 hours per week or permit access with a 48-hour notice of request. And again, I'm kind of continue preaching this, consider an internal procedures manual, how to deal with electronic requests, which is really important, working with requests on records. And then again, the internal procedures manual will provide consistency and help make sure that you are in compliance. A request. Any person can request a record or a copy of a record, an inspection or a copy of a record. They do not need to identify who they are, what their motives are, what their purpose is. They can just come in and say, I'd like to see this record. They can ask oral or by written form. No specific form is required. If you have an internal procedures policy, you could create a written form for records requests. The person does not have to fill it out, but most often and most likely would. What's a sufficient request? If they want to inspect it, that's sufficient enough, but they have to reasonably describe the record or information. They just can't ask for all emails for some elected official for a calendar year, for example. Probably not reasonably described. Must be because of the time and subject matter. The custodian of the record should not have to guess as to what the person's looking for. And because the record request cannot so burden the custodian so that normal office functions are impaired. Again, that asking for emails for an entire year might do that. Responding to a request. The statute says as soon as practicable and without delay. The Office of Open Government basically suggests 10 days to respond. If you have a records policy, you can put your response times as part of that. There are penalties for arbitrary and capricious delay, but not much of a definition of what that is. Only records that exist at the time of the request are required to be produced. So if someone comes in and says, I want the meeting minutes for the last meeting of the Board of Supervisors, and I want all the meeting minutes for all the future meetings, you only have to provide minutes as a record that exists at the time. You do not have to provide future meetings.
And real quick, maybe one clarification on an arbitrary refusal. If you say that you'll respond within 20 days, you know, the overall requirement is as soon as practicable without delay, as you have up on the top there, which would mean if you wait to the 9th day to do something that could have easily be done within 1 or 2 days, then that would probably be an arbitrary and capricious restriction. So that's a caution that the Attorney General's office gives.
Good point, Philip. Thank you. Responding to the request. You have to provide the records, but you do not have to answer questions about the records. You may transcribe audio records. You can provide a photocopy or allow inspection. Again, no provision in the law for continuing requests. The Office of Open Government suggests communicating with the record requester about what they're looking for and what they need, and so that you're better able to work with the requester as to what they're trying to find. That communication will help understand the request, help you understand whether what record exists or not, what the format is, and the response time and updates to the records request. Format of records. A copy is substantially as readable, audible, or as good as the original. The wire data case involved whether records must be produced in a record requested format, not squarely addressed. Luter's case basically said if they ask for the metadata, you have to provide it. PDF fulfilled the request for electronic records. And that one, what's important about that case is to note that it's sufficient to provide a copy of relevant data in appropriate format. That's really the key there. Personally identifiable information. If the record contains personally identifiable information, exceptions for investigation, security concerns, or unindexed records, your ability to request correction, you have the ability to request correction, and public employees and officials have the right of notice of certain records. So if you get a request about a public employee or official, my recommendation is talk to your corporation counsel before releasing the records to make sure that you've dotted all your I's and crossed all your T's. Limits on access. The statutes have some limits. There are some court decisions. The balancing test, which we'll talk about next. And keep in mind, if parts of the record are not subject to disclosure, but other parts are, you must disclose the parts that are, and you must remove or redact the parts that are not subject to disclosure. So a request analysis, if you use the balancing test. Does the responsive record exist? Is there an absolute right to access? Again, usually, but not always. Is access absolutely denied? Rarely, but possible. And apply the balancing test. And that's all from the Office of Open Government. So first, does the record exist? Only records that exist at the time of the request must be produced. The authority does not need to create new records to respond, and the public records law does not require answering questions about the records. However, if the request asks a question and an existing record answers the question, the Office of Open Government suggests that you provide the record and inform the requester. Again, continuing requests are not contemplated by the law, and if there are no responsive records, you're not required to inform the requester, but the Office of Open Government suggests that you do, if for no other reason, just to make sure that you maintain good relations with your citizens. Is there an absolute right or denial? Absolute right, not many exist. Books and papers required to be kept by a sheriff, clerk of circuit court, other specified county officials. Daily arrest logs. As far as absolute denial, some are in the public record statute, such as in current investigation of a possible employee, criminal conduct, or other misconduct. Plan specifications for state buildings. They can be located in other statutes or case law. For example, district attorney prosecution case records are not disclosable. Patient healthcare records are not disclosable, and pupil records are typically not disclosable. So when you apply the balancing test, does the public interest in non-disclosure outweigh the public interest in disclosure? You have to state the specific policy behind the non-disclosure. Closed session exceptions are possible policy reasons. So if the county board went into closed session to talk about a personnel matter or a land sale or a lawsuit, those records, those closed session records would fit the non-disclosure versus disclosure. It's always a case-by-case effort, so there's no bright line rules. Denial of access. Oral requests are denied orally unless the demand is made for reasons in a written statement, and those are due within 5 days of the denial. Written request denials are always required in writing back, explaining the reasons, and advise that the denial is subject to court review. So you not only have to tell the person in writing why you're not providing the record, but you also have to have a sentence or two in there noting that this denial is subject to court review. Denial explanation, I always put wait, don't tell me. It has nothing to do with denials, but I always like the wait, don't tell me part of it. It's make sure it's sufficient on the public records law, specific enough for the requester to understand why they're not getting the record, and the basis and the limit of court review. So the Office of Open Government on fees, charging fees, the authority may charge the fee for the actual, necessary, and direct costs for 4 specific tasks. That's under the statute: reproduction and transcription, photographing and photographic processing, locating the record, you have to use your IT staff or others, mailing or shipping. Those are all allowable costs. Staff time. The rate for the actual, necessary, and direct charge should be based on the pay rate for the lowest paid employee capable of performing the task. So you can't charge, if you have an employee who's making $15 an hour who can find the record and provide it, you can't use an employee that charges $300 an hour to do the same task. That's what they mean there. You can require prepayment for any costs over $5, but you cannot charge for the time it takes to redact records. That came out of a court decision. And then a couple of years ago, the Office of Open Government came out with a fee schedule for what they will charge for records, and made it pretty clear that if you're going to charge significantly more, so for example, if you've been charging 25 cents a page for a copy, the Office of Open Government concluded that actual cost for them was more like 2 or 3 cents per copy. So if you're going to charge 25 cents per copy, you better have a darn good reason as to why, and be able to show the math. Enforcement. There's a court order disclosure. Basically, a person would bring a mandamus action demanding production. possible payment of the requester's attorney's fees and costs. That would be up to the court. Punitive damages for arbitrary delay or denial. Loss of public confidence in the unit of government is always a big issue. And we're going to spend just another couple slides here. One on the Wisconsin Municipal Records Retention Schedule. It's the adoptable general records retention schedule approved by the Public Records Board in 2018. You can adopt the WMRS, or you have another approach. Another approach that you can use is the Wisconsin County Association has a record retention model ordinance that's tailored more to what county, the types of records that counties keep. And that's available at this website address. I highly recommend that you take a look at that if you don't have a records retention schedule. The key is, and then also if you decide to destroy any records, you have to notify the Wisconsin Historical Society 60 days prior to any public records being destroyed. But for purposes of the Wisconsin Municipal or Public Records Board, if you've adopted their approach or for example, WCA's approach, then you do not have to ask permission from the Public Records Board. Just notify the Historical Society. So when I put this program together a couple of years ago, I had a conversation with the Wisconsin Freedom of Information Council, and I basically said, what did you hear about complaints about open records from your members? And primarily they're members of the news media. Long waits for records request, the cost to comply, the communication between the record holder and requester is usually poor, and they would like electronic records provided, not paper records. So it's easier for them to use the data. Then I asked the Office of Open Government, what do they hear? Compliance time, fees, cost to comply, electronic records, communication between the record holder and requester. And the other interesting thing is 80% of the Office of Open Government's training is on public records, not open meetings. So I thought that was interesting. I also thought it was interesting that when you look at the reasons given, they're almost exactly the same. We have some additional resources. Again, the 2020 County Officials Handbook, pages 85 to 102. Philip has done a terrific job of summarizing the requirements. We have a fact sheet at the local government center. The Department of Justice Office of Open Government, Paul Ferguson's information is noted there, the Historical Society, Public Records Board, and of course the statutes themselves. With that, thank you. Do we have any questions?
Yeah, Daniel, I've been managing the questions myself,
Yay.
so you might want to check the answered box, and if you have anything to add, you could do that. But we had about 5 questions, and we had some questions coming in through chat, and just remind everyone that that's what we're looking for. Also, I'm getting notice that people have raised hands. Again, if you have questions, look to the bottom of your screen. If you aren't seeing it, take your cursor down there and it'll get highlighted. And there's a little bubble on the right-hand side of the bar down there. It says Q&A, and that is where you can ask your question. So, and since we've had raised hands, maybe somebody will find that and have one before we switch over, Daniel.
All right.
I'm just wondering as well, since we do have a few folks on the phone that cannot access or see the Q&A, since they were short questions and answers, I don't know if you just want to run through them very quickly.
Oh.
Philip, do you want to go ahead and do that since you answered them?
Yeah, okay. Well, right now there's one pending asking if junk mail is into your official account. And I would tend to say no, especially if you don't read it and you don't maintain it. If you just mark it as junk and it goes right away there, if you read it and put it into your archive, well, then you are the custodian of that record. And if it refers to government business in any way, then you have that situation. The other questions that we have was asking if a draft resolution is public record, and If it's a draft that you did and it's only for you to look at it, it's only for your use, then it is an exception. But if you share it with others, then it is a public record. There is a specific definition in the statute of what a draft is. What we think a draft is means that it's not quite ready for prime time. But under the Opens Record, to get that exception, it has to be only used for your own personal purposes. Also, there was asked about social media accounts, and I would say it would depend on your content. And it was odd because as I was typing that, Daniel was saying exactly that same thing. But there is a specific case where a blog was kept by a town supervisor, and they would only let people had to ask for permission to see what was on the blog. And the Attorney General said that you cannot do. If you have that kind of information regarding your duties on the internet, then it has to be accessible to the public. So if you do a Philip Freeburg County Supervisor Facebook page, then that page should be available to the public, and they shouldn't have to ask to be your friend. And another question was asking about what kind of additional information. I think we got that answered in the presentation. The additional information you get in metadata is like the author, the time of creation, how many times it may have been altered or answered, that kind of thing.
And to add to that,
union contracts.
Excuse me, Phil. And to add to that one, the other thing it gives you that you wouldn't see necessarily from the printed version is who else has looked at the email or contributed to the document.
Yeah. Daniel, then there's two questions in there. I don't know if you can see those, if you want to do that or.
Yeah, I'm not aware. Let's see, you asked, you covered the union contracts or public record. The answer is yes, those would be public records. I can't think of anything that would allow them not to be a public record. And then the last one, Philip answered about the junk mail. So I would suggest on that one, don't let the junk mail build up on your email accounts. Delete those daily. That way you're not maintaining the record.
Yeah, there's two open questions as well.
Oh, missed those.
Yeah.
Is there still a requirement that each county agency that holds public records must have a records release policy posted for public inspection or public access to the records? You have to have a policy, or you have to have a notice up saying who's responsible, what the costs are, and when the records are accessible. And so I'm not sure if you're talking about records retention policy, which the answer would be yes, or if you're just talking about the notice required by the statute. Philip, do you have any ideas on that?
Well, I would say, yeah, if they're a custodian of the records, then they are required to have a policy.
How does having to run a data set equal a record that already exists? I find that confusing. Isn't that creating a new record?
You know, that's under the old definitions of the statute. Used to be, it was when there was computer information, you had to run a data. They weren't as retrievable as easy as they are. So it was the only means to get it. I think the exception is that if it's possible to retrieve the documents and do so in an expedient fashion, then that might be running a data set. But there might be the other thing where if you have an extensive record and you have to do a search, you know, that sort of thing might involve time and that sort of thing. But I think that's a good question, but my own impression of that is that that part of the statute is a bit of an anachronism. I don't think that's as big a problem, but sometimes it could be. I think the best example would be like, you know, you request a voter roll. That seems to be actually a run. You know, there might be one copy, but you know, really to get somebody a copy, they would probably. Well, even then, most places would just provide you with an electronic document.
And Sarah makes a note about texting. So if you're in we covered this a little bit in the open meetings law, but Sarah makes a good point. Don't text people because one, you might be in violation of the open meetings law, depending on how many people got the text and how the text is being distributed. And you create a public record at the same time, because now that's a public document. Again, from the content perspective, not where it's located. Another person asks, clerk of court fees, different from fees county can charge? Yes, any statutory mandated fee is the fee, regardless of what the actual costs are.
Yeah, another example would be register of deeds. There's a statute that says they could charge $2 a page. Can social media posts on your personal page become public record as a county official? Philip, I think you just answered that, but. Yeah, again, content. You're just talking about your fishing and your grandchildren. You're fine. You put in there saying we had a really challenging day at the meeting at the county board, but we're doing a great job and making lots of progress on dealing with the pandemic. And boom, your content is all of a sudden regarding your function as a public record. So, so be careful and be cautious. Tell you how, when I was a public official, I made it easy. I wasn't on Facebook when I was a municipal judge.
And related to that, Philip, if I have a candidate Facebook page that I'm no longer using, is it safe to delete that?
I'm not sure what the requirements are of the elections commissions. I would check that before deleting it. There may be some record retention requirements there I'm not aware of, so I would hesitate to answer that, because you hold a whole nother regulatory scheme that neither Daniel and I are prepared to address. So I would forward that to the elections commissions, maybe with a phone call or an email.
And then another Facebook or social media related question. I was told we need to keep our Facebook pages, videos, pics for 7 years, and I should download them frequently to keep track. I guess there's a program that does this, but is keeping the page public enough?
I would say that, the advice that we often give regarding using social media is that does not go away. It's permanent, and if you delete it, I would caution you, it may not be gone permanently, but your record retention requirements are spelled out in your policy for your county. So if you were told 7 years, that must be in your policy, and that's where you would look regarding record retentions. This talk is just talking about what is public records, and is not a discussion of record retention requirements.
Next question, texting to one person is an open meeting laws violation.
Is that a comment or a question?
Looks like a question. Yeah, I think the answer to that is dependent on how far that texting goes and who all it goes to. If you're texting another committee member and you have a 3-person committee, then you and the other person constitute a quorum. Therefore, that text could be an open meetings law violation. It also has to meet it's a numbers and purpose test, which we just talked about the previous session. So,
well, 2 things I want to add to that too, Daniel, is, this is a records discussion. And if you're texting to somebody about county business, you just said a text, then that is a public record. No ifs, ands, or buts. If somebody texts you or emails you about county business, or they send you a letter, there is a court case specifically on this. That correspondence is a public record.
Then 2 more social media. Is Facebook message from a constituent considered an open record?
Just answered that.
Yep. And are people starting to look at how to use social media to inform the public in a way that follows the rules? Social media is the main form of communication for young generations. How do we engage all these generations without embracing social media as a tool of this decade as email was 3 decades ago?
I think there's a setting in Facebook, you just make it a public page. I think the concern that was before is if where you have to okay people to see the page, that would be a concern. That would be a denial without any rationale or you know, that's where you would run into problems. So it's not saying don't use it. I guess my comment was to keep it simple, but I understand the comment. Yeah, you know, just be aware, just be smart, and that's probably one of the advice we often give is, you know, conversations you have on social media are just like conversations you have in real life, except that more people see and hear it, and it doesn't go away.
All right, and then the last one before we get to your presentation, Philip, does there have to be an explanation for extensive record requests by a public official? Are there any costs considered? If someone comes in and asks for an extensive record or a whole lot of records, and it's going to take you some time and cost to do that, then the explanation would be around the time and those costs. Not sure what other explanation might be. Philip, do you have anything to add to that?
Yeah, well, the statute spells out again exactly which costs you can charge, and there's a slide on that reviewed that. Go back and you can see those itemized. I think the important thing to remember too is whatever cost it is, it has to be an actual expenditure, and it has to be one that the statute authorizes.
All right, Philip, I turn it over to you.
Okay, Daniel, as you turn it over to me, I have this curious thing here again where I cannot see the questions and answers, so I would need you and Sarah basically to monitor that for me.
Will do.
And good morning, everyone. I'm going to, well, I can't share my screen either. All right. Chelsea, do you have any advice on that?
Let's see. This might be an easy one, but you try minimizing and then reopening Zoom. Maybe the toolbar is just bugged.
Yeah, that's probably what it is. Yeah, now I got a problem. So I'm going to log out and come back in. That's how I fixed it the last time.
All right, we'll see you in a minute.
Good.
In the meantime, while Philip is doing that, there is somebody who has their hand raised. I'm not certain how we get that question answered.
Sure. Linda, I'm going to hit allow to talk, and you can go ahead and ask your question if you've still got it.
Linda, do you have a question still? All right, it doesn't appear Linda has a question. Okay, just a couple of other things. I just want to mention again that all of the information, along with additional information related to all of the topics that we have talked about during the county officials workshops, can be found on the Wisconsin Counties Association's website, as well as the website of the UW-Madison Division of Extension, Local Government Education. I also do want to remind everybody that additional information on all the topics we discussed, plus more, can be found in the County Officials Handbook. We added a few things to the handbook for the 2020 edition. One thing I forgot to mention when we were talking about running effective meetings a few weeks ago, or maybe that was just last week, was a few years ago, we had Mike Glaska, who was our chief of staff at the time and our resident expert. He had a monthly column in our magazine that answered frequently asked questions with regard to parliamentary procedure. All of those items are listed or have been reprinted in the 2020 edition of the County Officials Handbook. Also, if you'd like additional information on all of these topics for your counties, we are more than happy to come visit you at your county when it is safe and appropriate to do so. Or we are more than happy as well to attend your county board meetings via Zoom to provide additional education. So I think Philip has his screen up and is now ready. So I am going to turn it over to Philip.
Yeah, we're live and we're going to rock and roll here. So it's very interesting. I was at a Zoom conference on Thursday where they said you should have a second device ready to run your programs in case something goes wrong with the first. And I said, well, that's gilding the lily. But clearly, I just learned something important here. So we're talking about ethics and conflicts of interest this morning. And this is what I want to get covered here today. Going over the policies that are involved, why these are laws. So when I'm saying ethics, we're not purely speaking of a moral obligation here. We're talking about legal requirements that are required of public officials in Wisconsin. So foremost of that is the Code of Ethics for local government officials. The other primary statute that you're going to be made aware of through our presentation is private interest in a public contract that is prohibited for public officials. And we'll also cover what the law considers incompatible offices and new offices. What are new positions or offices which you as a county official are prohibited from, by law, from obtaining? And lastly, because in the time allotted, we can't cover everything else, I'm going to review for you and highlight for you some resources and some subject areas that you want to delve into. I'm giving what I believe here is the essentials for this. And I'm going to begin by getting you involved. If you look on your toolbar, there is a poll there, and click on that. And I want to ask you this question: why did voters elect you to be a county official? And there are 4 considerations, and answer the one you think is the answer. And I see we have a vigorous participation in that, and that's excellent to see. And of course, those results are being shared with all of you. But in a word, I think everybody thinks it's a little bit of they trust me, they think I'm reliable, and they believe I put the county first. You will see that when we wrap this up, this question is something I want to circle back to when we complete our discussion. So, oh, and I see, all right. So there's our results. Yeah, it's a little bit of all of them. And a few people saying, I'm not exactly sure. Yeah, and sometimes you do wonder. Now, I'm going to close this one and we're going to move on then. And we're going to talk about why these laws exist, because this is important to keep in mind and why they are there. One reason is they're put in there to limit a public official using their office for private profiting. In other words, you're in a position of trust of minding affairs for your entire community, not just yourself. So many of these restrictions are there just simply to keep you from profiting from holding a public office other than the compensation which you're justly entitled to. The other thing is to avoid conflicts between what is your purely personal interest and your public responsibilities. And by doing that, the public has greater confidence in the integrity of the decisions that you make as a public official. With the restrictions on conflicts, they know that you're deciding based on the interest of the county rather than any private, and especially any private financial interests that you might have. And lastly, some of these may seem arbitrary. They are restrictions on your conduct, and you can't see how a violation would really necessarily harm someone. And the reason those restrictions are put in place is to simply avoid any appearance. In other words, we're going to draw some bright lines here, so we don't even have to get into analysis of if there's a conflict or not. Let's just say there's going to be some hands-off involved. Now, I'm going to begin here with the Code of Ethics for local officials. This is for local government officials, of course. And there is a general ethics code called the Code of Ethics for local officials. That's in the statutes at 1952. It's important if you go there to look that you're also going to need to look at the definition section as well, because many of the words used in the statute have specific meanings, similar to what we were talking about, what a draft meant under public records law. There's going to be some terms, and I'll try to review many of those as they can, because otherwise, without the definitions, you're not going to understand the full extent or reach of a particular statute. So the basics are of the code, and we can cover this the time allowed it, is they deal with restrictions on private gain, regulations of avoiding improper influence or reward of public officials, and it helps you to define and identify conflicting interests, and a provision which I think for most county officials, unless you've got a highly partisan courthouse, the pay-to-play restrictions. And I'll just touch on that briefly to alert that one to you. But let's get into detail here about this specific provision. You have the first provision on private gain, and it says you're prohibited from using public office to obtain a financial gain or anything of substantial value for the private benefit of yourself or your immediate family or an organization that is associated with the officials. Now, all of those terms are defined in the statute. Who the official is for most of the people listening today should be pretty clear. But the organization associated with the official, that one I will talk about when we get to the third part, the conflict of interest provisions. The one that looks pretty easy, immediate family member, is not. That has a specific definition, and you'll see that it's a very restricted definition. It says that your immediate family, according to the ethics statute, is your spouse, or it's a relative you have by marriage or lineal descent. Relative by marriage would be stepchildren, mother and father-in-law. Lineal descent would be those blood relations that are in a direct line with you, so it excludes aunts and uncles and brothers and sisters. But that's not all. It's not just the fact that they're relatives. It is even more narrowed, is that relative then has to receive more than 50% of their support from the official. And that support is either directly or indirectly. So when my son got a bachelor's degree, he lived in our spare bedroom for 3 years, and I indirectly supported him 50%. And then the other part is if you're not supporting them, they provide 50% of your support. And if any of you have your children that are supporting you, please send me an email afterwards, because clearly, based on my 3-year example, I need some lessons on getting support from lineal descendants. So, okay. I wasn't getting the animations to work before, but now they are working again. Here's one thing, though. If you think about it, everything you do is for everybody in the county, and guess who lives in the county? So, you decide to, you're going to raise taxes. That's going to affect you, or you're going to create a new program that benefits a lot of people or benefits everybody. Well, the Ethics Commission, which by the statute provides that the commission will give guidance and opinions. And in one opinion, they said that if it is something where you are having a substantial financial interest, it may not necessarily be a conflict or problem if it affects a whole class of people similarly situated. And also that your interest is insignificant when you compare it to everybody else that's in that group. Or any benefit on you is neither significantly greater or significantly less for you than it is anybody else. So when you pass the budget and maybe you're in a fortunate year where there won't be a tax increase, is that a substantial financial interest? Well, yeah, but guess what? You did that for everyone too. So that's a very large class there, and you're not significantly less or more in terms of that class. I want to go back to polling again, and I'm going to begin, but I want to give you an example. So we're talking about using your office for private gain. So in this county that I made up, Fromage County Board, they elected Sid Carlton as its chair. And so when you come to the welcome page of the county website, it got updated, and it shows Carlton in his work clothes in his office. And this is his office for his business. And he has his own dental practice that is in the county seat. So, and the picture and caption on the message underneath, it says Board Chair Dr. Sidney Carlton, DDS. And I had a picture of Dr. Carlton, but apparently that is gone. But in the picture, to give you further background, he is dressed in his gown. He's wearing a mask, but aren't we all? But he has a cap on, and he's got a dental chair and equipment all behind him in the picture. So, so the question I'm going to ask you, and I'm going to open the polls, is do you have any concerns about Carlton's photo in the way that it's been described here, being on the county website? So I want to go to the next question. And if you could participate and give us your views on that, if you, knowing what you know about what we just covered about the restriction on using your office for substantial benefit. And if anyone is a dentist that's attending today, please don't take D personally. I am a lawyer, so I think we're not very popular for the most part. And as you can see, most of you are coming down with saying, hey, yeah, he's using a county resource to promote his own business. And there has been some opinions and guidance specifically on this point as recently as a couple of years ago, where, and this happened to be under the state code, but it's written the same way, where a state legislator had a picture of his contracting business on his state social media page. And so the concern was him using the office to for his own private benefit. So what do you do if you're about to take an action and you realize that this is going to create a benefit for you? Then you're to abstain. But under the ethics code, that has a specific meaning through interpretation. That means completely removing yourself from the decision-making process or the information exchange in your official capacity. It's not just voting abstain. And the example I give, and I'll give a more generic one, is you're on the county board floor and you talk extensively about a particular measure and you talk about the merits of it and how good it is. And you end your talk by saying, but I'm going to abstain because I have a conflict of interest. And you just use your position and ability to speak on the county board floor for your gain. So that's why if there is the conflict, you're to remove yourself totally from that process. Daniel, is that a question I can handle quickly, or Sarah?
There's no question.
Okay, good. Let's move on to influence and reward, which actually I probably should preface by saying improper influence and reward. But this one says that no public official may solicit or accept anything of value if that item could reasonably be expected to influence that official's judgment or could reasonably be considered a reward for official action. And those last two bullets are exactly in the statute. And the key point there is reasonably. When you see in a legal statute the word reasonable or reasonably, that means it's an objective standard. It's not a subjective standard. So it's like, I would put it this way, how does it look? What is anything of value? Well, as you're beginning to figure out, that has a definition. And that definition includes an awful lot, as you can see right there on the slide. Everything from money, which you say obviously, but some things maybe you didn't think of, like maybe just a favor or a promise to consider you favorably when you decide to retire from your present public office. There are exceptions to anything of value. Some of them spelled out in the statute. Some of them have come to us through interpretation by the Ethics Commission. Obviously, what you get paid for the job to be a county official is something that you're entitled to keep. If you have something that's really of nominal or inconsequential value, then that's not anything of value. And I think one of the best definitions I heard is from the retired chair of the Ethics Commission, who said, one easy way to tell is if you don't care if you have it or not, it's probably not something of value. You go to the Counties Association and you've got firms that have booths up and they want to give you a keychain or a pen with their name on it. Yeah, you probably don't care if you have that or not. You didn't go there just to get that. And the other thing on that is, go back to the definition where he says if it's likely to influence you. Well, there's advertising too, which is intended to influence everybody. So if these items are things that are being handed out to anybody, anywhere, anytime, then that particular peg of the improper influence isn't met, but also it may be of inconsequential, you don't care. Another type of exception is things that you receive or hospitality that has nothing to do with you being a public official. It's totally unrelated with government business. Some of the fathers and grandfathers out there might have received some gifts on Father's Day a week ago. That might be trying to influence you, but it's totally unrelated to your government business. Legally reported campaign contributions. I know that's a big problem for a lot of people with dealing all that money. Most of you will be not worried about that, but that is accepted. And of course, your outside appointment has nothing to do with your being improper influence or reward in terms of being anything of value. So we're going to go back to you participating again, and I am going to the next poll question here. And all right, I'm going to put this aside for now, but we're going to deal with Kate Nickleby, and she's drinking an old fashioned with her family while waiting for a table at a local supper club. Obviously a happier time and a supper club that is being very careful about distancing and the health of its patrons. The bartender brings over another old fashioned and says, the man over there bought this for you. And he points to someone at the bar. And then Kate's not sure, but she thinks she saw that man when she was at one of her forestry and zoning committees. So the question I have then is, what should she do with that old fashioned that's been brought to her? My favorite would be, my instinct would say, well, is this rail brandy or not? The other question would be, take the drink. And I think, look at this, 100%. I'm not even going to go through the rest. Because, yeah, that's where the group is coming down. And that's the obvious answer. If you can, politely decline it. One thing I wanted to point out is B may sound like a silly answer, but it's actually something I encountered when I was practicing. I had an official I worked with saying, well, you know, it takes more than one drink to influence me. If you want to get my attention, you got to buy me two. And I said, no, that's not what reasonably influence. It's what would an objective person, being very reasonable about the situations, how would it look to them, especially where it's hospitality has nothing to do with you personally. How else or why else would this person be treating you? So sometimes something of value is not hard to determine. Here's an example that came from a professor of ethics at a New York university. There was an argument where a defendant in a case was arguing that a Rolex watch was not intended to influence him. And the answer is in that headline of her opinion. There's no such thing as a free Rolex. So there you see that some of the questions that you'll be facing and challenges are not that hard. Here's a few bottom line things, and I will not claim authorship. This is from a guide that the Ethics Commission put out. You cannot accept a gift because you are a public official. You may receive gifts unrelated to public office. In other words, you don't have to. If they give you a pink flamingo for your lawn, you don't have to receive that from, if it's unrelated to your office. And you may receive gifts on behalf of your governmental unit. Somebody wants to give you something and you say, oh, well, that's very nice. And you take it back to the county and give it to them, or maybe you get reimbursed for an expense for a meal and somebody pays for your meal because you came and spoke to them, but you would have, then you can, that expense would have been reimbursed to you by the county anyway. I'm going to see if I can get to some of those questions.
I was just going to say you have two questions before you get to conflicting interests.
Is it okay to reward an organization and then join that organization after you leave office? That's a bit vague, and it may come into when we talk about what the organizations are that you're going to have to consider. So that's coming up next. So what I suggest we do on that is listen and then determine if you think that's still a question or an issue, and ask the question again. I would be very happy to take another look at it. And, oh, would it be okay for the dentist photo? Well, the problem with the dentist photo was that it would, and maybe for the people listening, I should go through all the answers here. But that would be a problem because you're using, essentially there was no necessity or need to have the information of the regarding the private business and profession of the county board supervisor. So that one is something that has been commented on previously. by the Ethics Commission. That would have been improper. If he just had his name up there and nothing more, maybe even doctor might have been okay too, but I would say better practice would be just the name, because just what he does in his public official business. And you'll see that with, there's two members of the US Senate who have similar rules, and that are physicians, and they don't refer to themselves as doctor. Of course, lawyers are doctors too, and we don't do it because we're arrogant enough as it is. Conflicting interests. This is the third statute. And this is where we're going to talk about those organizations that you're associated with. In this one, it says, no public official may take any official action substantially affecting a matter, in which the official's immediate family, or an organization which the official is associated with has a substantial financial interest. And as you see, this is one where the financial interest is involved and the decision-making is going to be affecting that. And on the county level, I haven't been very good at coming up with an easy example, but I will take it to the city or municipal level or town. You run a tavern and a vote is coming up on issuing your liquor licenses and the liquor licenses of all your competitors. That substantially affects your financial interest. And that would be a problem with this statute requiring you to abstain. Now, this statute has a second subpart that says that as a public official, you may not use your office to actually produce or assist in the production of a substantial benefit for the official's immediate family or an organization for which the official is associated. And going back to that question about this one, both of these kind of see where that question is. I said, listen carefully. This is where we're really discussing that question. So, all right, so we know who our family are. We know who we are. What are these organizations with which we are associated as public officials? Here is the definition, and I've given it to you as a bulleted list, which is pretty much how it's covered. Almost sort of gathering or organization you can think of, even an association. But there's a specific example for a body politic. Now, what would be an example of a body politic? Well, another governmental body. Maybe you serve as a school board supervisor as well as county supervisor, which means you're working very hard, but that does not an organization that would create a conflict for you. Well, now, if you're looking at this definition saying, yeah, but I can't do anything outside of the office at all. Well, remember, it's an organization that you're associated with, and associated with is defined in the statute. And associated is really only when you're somebody who is influential or calls shots for that organization. So it means that you are a member of your immediate family is an officer or director, owns 10% of that organization, especially, in a private business organization, or you or your immediate family is an authorized representative or agent in that particular organization. And it specifically says that membership and employment does not constitute being associated with the organization. Now, a quick thing, say you're employed and you're dealing with an issue of a possible contract for your employment, but it doesn't have anything to do with your department or anything. Remember, we still have using your office, for a gain or issues of conflict. For example, if it's kind of clear that your supervisors are not going to be happy if you vote down a measure in your county official role, then that'll take you beyond the statute. But otherwise, just being a member or just being employed by the organization when you don't have any other influential role is not enough. So here's another poll I'm going to go to, and the question I have is, you're going to do, and I think we missed the question. The question I'm going to give you is, let's say you are voting on your town supervisor as well as a county official. And you're going to do a highway project that is located only in your town. Are you going to abstain from that? And thank you, Chelsea, for helping me out with that. Now, I think this is I hope, maybe a challenging question, because it is really drilling down very carefully to the statute and its definitions of organizations you're associated with. So we have most people saying that it's not a problem, and that is the answer. Which, by the way, I realize now I'm using the slides that I use for materials, and so I don't have the answer slides here. I would ordinarily put those back up, but I've already delayed enough time when my computer went on a rebellion with me. Let me explain why that is. Oh, well, the reason that is twofold. One is, as I pointed out, being a town supervisor, you're associated with a body politic. So that's outside the definition. Another level of comfort comes in because in Chapter 59, there's a specific exception that permits county supervisors to also serve as alderpersons, town supervisors, and village trustees. So the correct answer there is no, it's not a problem. Okay. Now, this pay to play restriction, real quickly. You're not to use your office to obtain a political contribution or anything of value that would benefit a candidate, a party, or a political committee. Best example I could say, this is very similar to one of the counts of impeachment against the president, was an allegation. But here in Wisconsin, we have a specific statute that covers that sort of conduct. So if somebody says they want to talk to you about zoning in the county, and you say, well, before we talk about this, why don't you come to my fundraiser for my friend Daniel Foth, who's running for the state senate. We can talk about it there. You're using your position to get a benefit for a private political basis. What happens if you run afoul of these statutes? Well, there's a forfeiture, a civil violation, in other words, a fine, and that is without court costs and penalty assessments that are added on to fines. So it could be up to $1,000. I think one of the most significant ones is courts under the code, and even before there was a code, when they realized that there was a significant conflict under the common law, a court could void any action. They could, in other words, undo the vote and make it be redone. Or under the statute, they can require restitution. Say you voted for a contract that you benefited from, they might require you to pay it back. If you know you did the violation and you intended to do the violation, then it's a criminal violation with up to a year imprisonment or a fine. And it has also been opined, in other words, an opinion given, that you have to have a cause to remove an official from office, but it has been a legal opinion that violating the ethics code would form that sort of basis. Let me see if we can take some time for some questions here, and I've gotten it where I can get at it now. The question is, it's a very long one. It doesn't look like a question, I guess. Annexing or rezoning so to create or expand a public hunting and connecting to the public-private property. Ms. Gatlin, I guess I would ask you to rephrase that. I don't understand what you're asking on that. I think what you're asking is, really goes to that question of that analysis is this is where there's a, and it's kind of a good point. You're saying this may be a subset, or this may be an organization that you're associated with. I guess you got to know the specific facts here. So what I'm going to point to look at is, well, first of all, consider whether that private hunting and fishing club is an organization with they're associated with. That would answer one way if you have a conflict. If you're not really associated, you're just a member, it doesn't come under the statute. You may want to consider, you know, the common law conflict that I discussed before about the employer. The other one is if you're using the office for gain. Again, that one I would say, well, are we talking about an organization that's only 5 members of the hunting and fishing club? I would say you got a problem there. I think then you're not a member of a larger subset, and it's impacting you more than the public at large and significantly more than everybody else. That's the sort of analysis you do on that question. Next question we have is, when an elected official has a conflict of interest, one of your slides said not just voting. Yeah, well, what you do is you completely remove yourself from the process. You don't discuss it. I've even seen it recommended that you step away from the table or maybe sit out in the audience if you want to hear the debate, if you have an interest. You know, just think about it. If you've ever had a teenager, have you ever talked to them and they've never said a word, but their face is speaking volumes about their opinion about what you're talking about? I think that's part of why they say remove yourself totally from the process. Now, here's the next question is, when an official has a conflict of interest, okay, we just did that, didn't we? Yeah, that's a similar question, and we just covered that. When voting on county highway project and your son works for the bidding company, can you vote, or should you rescind, or actually recuse would be the word we use. In other words, you step back, and he's an employee only. Yeah, well, is your son supporting you by 50%, or are you directly or indirectly supporting your son? Then that's not going to trigger the statute. The one thing I caution is, though, there has been cases decided outside of the code where they say, well, if it could be shown you have divided loyalties and not the county's interest in mind, then that would be a situation where you should probably abstain if you don't want to be your vote later voided in a court action, which is too challenging. Okay, then we got a county. Okay, now this is a specific question, and I appreciate that. Let me suggest on this one. Okay. Yeah, your husband votes on, yes, I think you have to be careful, not about budget votes. The question is, this questioner has a spouse who serves on a commission or volunteers for the commission, the Aging and Disability Resource Center, and the budget includes, you know, that particular agency, and it would include reimbursement. This question comes up a lot before commission in teacher who are employed and a spouse is on the school board. Obviously, if you're dealing with a specific item, if you're voting on what the reimbursement rate is, that would be one you abstain from. In terms of the budget itself, that's an overall big document that covers all aspects of county, and the commission has given an opinion that that would be an exception. So let me suggest too that you not ask in a public forum personal questions. I have done this before, and I've had to call out somebody, and I really don't want to do that. So ask general questions, please. Is there a statute in the county that says cannot create a video in support of a political candidate? That has nothing to do with this. That has to do with endorsements, in-kind contributions potentially. It also has to do with First Amendment, not covered by these statutes at all. But you might want to look at campaign finance, which we are not talking about here, because that would be about a day we would talk about that one.
Philip,
Okay.
I'm wondering if at this point, because there are so many questions and we are at 10:25 right now,
Oh,
it
gosh.
makes sense for you to continue on with the presentation and we will get to the questions at the end.
Let's do that. I want to complete this. And so let's move on. The next item that I think it's critical for you to know, and just so you know, Chelsea, I guess we won't do any more polls either to move it along. Is there's a statute that deals with prohibited interests in public contracts. That's a criminal statute. You need to be aware of it because it involves strict liability. In other words, if you weren't aware of the statute or you didn't intend to violate it, it still is a violation. It deals with two types of conduct. What you do in your non-government capacity, what you do as a private business person or an employee, or what you do in your official capacity as a public official. And this covers public employees as well. The interest that you're prohibited in that public contract is as a county official or an employee, in your private capacity, you can't do anything to try to get that contract. Can't bid for it, negotiate it, can't even enter into it. If you have a direct financial or indirect financial interest, and sadly the statute does not talk about what an indirect financial interest is, but I think if you were running a corporation, the fact that it's a separate entity, still wouldn't mean that it wouldn't be an indirect benefit for you. But also, here's the real rub. If you have that financial interest and you're authorized or required to participate in making the contract, and that's what the statute says, if you're authorized to participate in the making of the contract, then you got problems. Because then you can't just simply abstain. Because this talks about things that you cannot do as in your private capacity because you're also a county official or a county employee. So the statute is a tough one in that it covers your private business conduct, not conduct on behalf of the county. And it's irrelevant then with that type of regulation, whether you're participating or not. How do you abstain from your personal business or job? Don't have the same process as you do as a public official. In your public capacity, you violate the statute when you have this direct or indirect interest and you participate in the making a contract. And interpretations of this by courts have said that participating is voting on it, discussing the contract, investigating it, recommending. In other words, it almost goes back to the ethics statute, taking any official action in any way regarding that particular statute. Now, this statute does recognize that there are some undue impacts on smaller population areas. And so the legislature, in creating this bright line rule, and this would be one of those ones I was talking about where they just draw the rule so that just totally removes any question of whether you have public influence or improper conduct. You just don't do it. But they do create an exception for $15,000 in any year, and that's a calendar year, and that's cumulative, so you can't have two $15,000 contracts. One thing I want to point out for counties, because I am aware of at least one county, counties under the ethics code can create a more restrictive local ordinance. And I know one county where a county corporation council called me up and told me that I misled one of their supervisors because they took away this $15,000 exception under their local code of ethics. And so in that particular county, which I recall is Portage County, and I think their corporation counsel is here, and maybe he can say something in chat if that still exists or not. So I should say he or she, I don't recall who the corporation counsel is. So that's a big exception, and that's in a calendar year. So if you got $15,000 paid on the 31st of December, on January 1, you're eligible for another $15,000. But it only applies to that where it says you can't have a private interest. So in your official capacity, you're still not participating in recommending, investigating, discussing, and voting. You're abstaining. And of course, you're abstaining then completely under the ethics code as well, because it would come under that very first thing where we talked about, taking an action that creates a private benefit for you. There are other exceptions for particular categories of persons. I've kind of briefly outlined those. That's a kind of a smaller subset than the $15,000, so I'm not going to talk about those in detail. But the penalties, it's up to 2 years imprisonment or a $10,000 fine. Remember, it's a Class I felony, which means the statute also says that contract's void. It's dead letter if you're convicted of this. And of course, if you're a convicted felon, guess what? You don't get to hold public office anymore either. So this is pretty serious. So, circle these slides if you printed them out, or make a note to yourself on your pad. Moving on then, since here's another statute you need to be aware of, is you cannot take a job as a county supervisor if it was created by the board during your term of office, which means if you want that job, you can't. It's called anti-feather bedding. You're leaving the board and you say, well, I'm going to go for that job that we just created. That looks pretty good. Well, to kind of prevent county boards from creating retirement plans other than legitimate retirement plans by having jobs that you can land in afterwards, this statute prohibits that. If it's an existing job, though, and you're on the county board and you said, oh, there's a vacancy in the emergency emergency government management, I'd like to go for that. And you can do that, but first you're going to resign before you take out an application. And that, again, there's a specific statute down there below to make you aware of that. Quickly, and this is hard because this is a difficult concept, but there are other offices in the county or other offices in government which you can't hold at the same time as a recognized fact of law in Wisconsin, which has been recognized by courts since 1907. If one office is superior to another office in some way so that the public interest would be hurt by the same person holding both offices, then you can't hold that second office. Or if you have two offices where maybe the nature of the two duties are that it's not in the public interest that the same person hold those. For example, where one office is superior for another one, there's some conflict as to some or all the duties of that subordinate office in some way. And the best example is a city example, but it comes from a court. There was a city employee, got elected to the city council, wanted to keep the job because city employees were paid better than city alderpersons. But the court said, wait, you're voting on your own terms of employment, wages, hours, and benefits. Those two offices conflict. You can't hold that. I would use the example that, say, an employee in the treasurer's office or the register of deeds could not run for the county board and keep both jobs. Where they conflict with each other, examples are, these are some that are actually spelled out in statute, but it kind of are spelled out because of this particular policy reason. Middle one is the one I talk about, sheriff and coroner. Coroner's job is to investigate deaths, conduct hearings, and determine a due process hearing of whether or not it was an illegally caused death. Whereas the sheriff investigates and presents the evidence for those types of investigations. And that would be judge and prosecutor at the same time. So that would be one example. And what happens, how are these enforced? The courts have said since 1927 that as a matter of law, you take that new position, you end up where you vacated the previous position you had. So you're on the county board, you apply for and get the job of that emergency manager, government management I talked about, you just vacated your county board seat. There have been statutes that have modified this. I think one example comes to mind is, EMTs, firefighters, there's exceptions for that. And there are other exceptions about being on other boards and commissions. But remember, any of those exceptions should be strictly interpreted according to this Wisconsin Court of Appeals decision. So in other words, they're going to be looked at very narrowly. And if you are on another board, you're okay so long as you're not receiving additional compensation. But if everybody else on the board is receiving the same compensation and they're eligible, then you can get that. Or if you're eligible for per diem from the county, you can get that. And remember, we talked about those other positions. There's that specific statute I referred to when we talked about whether you're associated with the organization of your town, city, or village when you serve on their governing body. Believe it or not, in the time allotted, we haven't talked about every ethics law. I want to alert you to the fact that bribery is still prohibited in Wisconsin. I don't think that's a shock to anybody, and I don't think I need a lot of detail. There's a statute called misconduct in office as well. It covers many of the same types of conduct that we discussed before, but that would be a criminal statute. You usually are going above and beyond, but we don't have time to cover those. I think that the other penalties, pretty much if you observe those scrupulously, you're probably not going to run into that statute. Just want to alert you if you're maybe on a body that has a quasi-judicial function, like maybe you're deciding if somebody gets a conditional use permit at a hearing or something like that, or maybe you're on the Board of Adjustment, that you are to avoid bias when you're acting in that quasi-judicial role, because you're looking at facts and applications and applying a statute or an ordinance to those facts. And of course, there are campaign finance and prohibited election processes, and I've already told you I'm ducking all those questions. Now, let's go back to the first poll question I asked you as to why you ran for election. And most of you said because people trust you, they think you'll put the county first, and they think you'll look out for their interests. Well, you know, I just went through a lot of rules, but I want to tell you, I think these are tools that'll help you do your job better, because you all described why you were picked to be a leader, why you want to be a leader, and all of these rules do restrict your conduct, but on the other hand, they'll help you in building and maintaining trust, reliability, and integrity as you do your job. Okay, before I say I couldn't cover anything, where can you find out more? The county's officials handbook has a chapter on ethics and conflicts of interest written by Andy Phillips and Conrad, Bennett Conrad. And so that's not shameless self-promotion, but we also have information on our website about ethics and conflicts of interest. I specifically point out to you, we have a document called a frequently asked questions, or FAQ, on our website, and it goes into a lot of details into many of the things we weren't able to cover here today. And I also want to point out to you, ethicswi.gov is the Ethics Commission's website. I will tell you this, they are, first of all, that's going to the source. They have a lot of information. I will confess, it's not the most easy to navigate website. So if you're going there, don't go if you're in a hurry. You might want to call up your corporation counsel and ask them rather than trying to figure it out from the website. Well, maybe you don't want to talk about it to the corporation counsel. Guess what? The statute under the Ethics Commission law says that that conversation is totally confidential, and any advice that's given to you is totally confidential. So you have some protections for going to get help, or if you seek it from another legal source. Now, we see that our numbers have diminished a little bit, but most of you are here. Sarah, you want to pitch the questions, or you want me to read and go through them?
I can run through them quickly if you like.
Okay.
Okay, we have somebody that has multiple titles, and at the end of their personal or professional emails, they include County Board Supervisor. when they are sending out emails? Is it appropriate to have their title as county board supervisor or their other titles listed if they use the county board supervisor title?
Very interesting question. Let me tell you what alarm bell goes off in my mind. One of them is the public records one. One way to keep your public and private records separate. I'm assuming one of these, this is private and public functions. Then if it's private, I would say don't put county supervisor on there, because then you're using your position to try to enhance your private business or whatever status. And another example of that would be when, say, somebody wants you to write a letter of recommendation to an employer. If they worked for you from the county and you knew them because of their work for the county, then put on there you're the county supervisor. If you're doing it just because you know them because they used to work for you in your plumbing business and you want to throw in their county supervisor, you put it on your county supervisor letterhead if you have that. That would be using your position, to create a private or personal gain, and that's where you need to keep it separate. Again, Daniel didn't talk about this, but for both ethics and public records, it's highly, highly recommended that you have separate emails accounts for your public functions. If for no other reason, that won't decide if it's public or private for public records law, but it'll be easier to find and maintain and deal with. What about sharing social media posts promoting fundraisers unrelated to the official food drives, charities, and candidates? Yeah, we had that come up in another context, and I pointed out that there may be some issues there. Remember, if that would be of a financial benefit and you're associated with that organization as an influential person, in other words, as an officer or a director, that could be a concern. If you're not associated with it, probably not, would not be the same. And again, when we're talking social media, I'm assuming we're talking about an official public social media, or like speaking about it on the county board floor. Remember, the key is using your position for a private benefit, but this benefit would be a question of whether or not this is an organization that you're associated with. So it's not a blanket no, it's a think about it is the answer. Is there a statute of limitations on enforcement of it? Yes, I think, as I recall, it's the general forfeiture limitations, which is 2 years. What does the state statute indicate about public display of political signs on government meetings, committees, and county boards? Again, there's a statute because frequently you're at a polling place, and a lot of other regulations are going to come in. Let's confine the question to the ethics one. And the question is, are you using your position to benefit somebody, particularly as a condition to you exercising your position? I'm not going on the county board floor unless I can, wear my Jimmy Carter t-shirt. This sounds like a joke, but I actually owned one 30 years ago. Keep in mind that it's talking about that. So the real question is here again, is it a matter of private personal gain, or is it a matter of you using your position for as a condition? Is you're using your position conditioned on you promoting this? And then, I think otherwise you're getting into First Amendment conduct. You also may have rules of decorum that have to do with your board rules that I think you're going to need to think about. But otherwise, I think we're getting heavily into First Amendment territory here, because in the ethics rule, the question is using this for private or personal gain. And you do have the pay to play, but that's the one saying that somebody's got to do something for a politician before you're willing to exercise your official duties. And I'm not saying that's what you're suggesting here, but I'm just saying that's what comes to mind. And yeah, same thing, candidate endorsement. Yeah, that's first of all, how are you gaining personally or privately because of a candidate endorsement? Unless you've got a side deal for an appointment or something, absent something specific like that, the question is, how are you gaining by that? And you're not. Your gain is as a participant in the political process, which the First Amendment protects, and you're not engaged in that at all. But private employment, different story, as I explained. How about that? I got through those and finished it in about 15 minutes here. Are there any other questions that we have? Otherwise, I'm going to stop sharing my screen and we will go back to normal. And I think you will all leave it to me to bid farewells. I will also tell you, if you did not get the materials, visit Counties Association or ours, University of Wisconsin-Madison, Division of Extension, Local Government Education. And in a few days, you will also see the video of this on both of those websites available for you to watch. And thank you all for kind words regarding this. Yes, I'm sorry that I have some bad puns when I used a fromage for the county, but I do that. Which means I hope you enjoyed the presentation. More of all, I hope you learned, and I hope I excited your interest in doing a better work. And I want to take a moment to thank you all for your time. And I wish your constituents knew how much time you all have spent trying to do your job better and knowing you're going to keep doing this over the next 2 years and probably longer. Sarah, you have anything else to wind us up?
I don't think so. I think I said most of my closing comments while you were rebooting.
Oh, okay.
Use that as filler.
Yeah, okay. Well,
So,
and
but
after
yeah, I just want to thank. Yeah, I just thank everybody for participating and know that this today it's not over. Just because the official COUS presentations are done does not mean that we are not available to continue to answer questions or to give additional presentations and information to your county boards or to your committees.
As Isaac Asimov once said, education is not something you finish. It's a continuing and ongoing. But I think I'm not going to say anymore because I think you've all had your fill today.
All right. Well, thank you so much for joining us.